Andy, the FDA v. RJ Reynolds Vapor Company case, what was at issue here? What was the FDA trying to do?
Well, Mark, this case is about when individual citizens and small businesses who are injured by agency decisions have access to the courts to challenge those decisions. Here, this case was brought by a number of convenience stores and gas stations who sold certain e-cigarettes. The FDA decided that they had to take those e-cigarettes off the shelves. And if they failed to take them off the shelves, they could be fined and even conceivably sent to prison. The convenience stores and gas stations believed that under the law, they were permitted to sell these products, that they were safe to sell, and they disagreed with the FDA. They tried to take the FDA to court under a law that Congress passed that permitted anyone adversely affected by an FDA decision to go to court.
And they did this in Texas?
They're located in that region, so they sued in their local court. They filed jointly with RJ Reynolds, who's based in North Carolina, in one lawsuit, so that enabled RJ Reynolds to sue in Texas. The FDA didn't want RJ Reynolds to be able to join in that suit in Texas, so what it did was it took the position that none of these small businesses who were injured by this decision had a right even to sue.
So the case in front of the Supreme Court really boiled down to, can this case be brought in the Texas district courts and in the Fifth Circuit, or would it have to be brought elsewhere?
I'd boil it down a slightly different way, which is even more basic, which is, can these small businesses sue at all?
Okay.
And because of the concern that you correctly put your finger on, the FDA tried to get around that by saying, well, we think these small businesses, they shouldn't be permitted in court at all. Only the big guy who manufactures these e-cigarettes can sue. The FDA issued an order that said RJ Reynolds can't market these e-cigarettes that have been on the market.
And what did the Supreme Court decide in this case about who can sue?
The Supreme Court disagreed with the FDA and agreed with the small stores. It ruled to keep the courthouse doors open for anyone who was adversely affected by the FDA decision.
So why should people outside of this case care about it?
They should care because the same problem isn't limited to the FDA and the companies it regulates. It applies to many, many agencies across the spectrum. There are, of course, many, many federal agencies. In this case, for example, we submitted an amicus brief to the Supreme Court where we explained that this same concept of permitting adversely affected companies and people to challenge agency decisions applies in more than 100 statutes. And the Supreme Court actually cited that in its decision, and that shows the very wide impact of this decision. It's a very important step in keeping the courthouse doors open for the many people that are affected by decisions made by the administrative state.